Hey everyone, welcome back to Neat Law, the place where we simplify the law, minus the yawns. Today we're talking about something every law student needs to master: contracts under the Indian Contract Act, 1872. Specifically, Section 2(h), valid contracts, voidable ones, and more. Let's go. What is a contract? Section 2(h) of the Indian Contract Act defines a contract as an agreement enforceable by law. Let's break that down. A contract equals agreement plus enforceability by law. So if I say, I'll pay you 1,000 rupees if you get me coffee, and you agree, that's not just a deal between friends. That's a contract, if both parties are legally competent and consent is free. Key point. Not all agreements are contracts, but all contracts are agreements. Agreement versus contract. Quick comparison for your exams. Agreement is just a mutual understanding. Contract is that mutual understanding plus legal enforceability. Think of it like this. You agree with a friend to go for lunch, that's an agreement. You sign a lease with your landlord, that's a contract. Essentials of a valid contract, Sec. 10. For an agreement to become a contract, it must meet Section 10's criteria: free consent. Competent parties. Lawful consideration. Lawful object. Not declared void. If any of these are missing, the contract fails. Simple. But first, what do you mean by types of contracts? Aren't all contracts the same? Good question. Contracts are classified based on three things. Enforceability, is it legally binding? Number of parties, is it one-sided or two-sided? Legal effect, is it already done, or yet to be performed? 1. Based on enforceability. So what does based on enforceability mean? It means whether the contract can be enforced in a court of law or not. Let's break it down. 1. Valid contract. A valid contract has all the essential elements under Section 10 of the Indian Contract Act: free consent, lawful object, consideration, capacity, and not declared void. Example. A agrees to sell his bike to B for 20,000 rupees. B accepts. This is a valid contract. 2. Void contract. Host A. These are contracts that were once valid, but due to some change, become unenforceable. Example. A agrees to export goods to B, but before shipping, the government bans the export. Now the contract becomes void. 3. Voidable contract. Here, one party has the option to cancel the contract, usually due to fraud, coercion, or misrepresentation. Example. A tricks B into signing a contract. B can either continue or cancel. It's a voidable contract. 4. Illegal contract. This one's simple: the object is unlawful, immoral, or criminal. Example. A hires B to commit theft for 50,000 rupees. That's an illegal contract and cannot be enforced in court. 5. Unenforceable contract. The contract is valid, but can't be enforced because it's missing formalities like stamp, signature, or proof. Example. A verbal agreement without witnesses or written proof, it's unenforceable. 2. Based on number of parties. Alright, now what about based on parties? 1. Unilateral contract. Only one party makes a promise, and the other party accepts it by performing. Example. A announces 5,000 rupees reward for anyone who finds his lost dog. B finds and returns it. That's a unilateral contract. 2. Bilateral contract. Both parties make promises. It's the most common type. Example. A agrees to build a website for B. B agrees to pay 10,000 rupees. Mutual promises. That's bilateral. Fraud, coercion, or misrepresentation. Example. A tricks B into signing a contract. B can either continue or cancel. It's a voidable contract. 4. Illegal contract. This one's simple: the object is unlawful, immoral, or criminal. Example. A hires B to commit theft for 50,000 rupees. That's an illegal contract and cannot be enforced in court. 5. Unenforceable contract. The contract is valid, but can't be enforced because it's missing formalities like stamp, signature, or proof. Example. A verbal agreement without witnesses or written proof, it's unenforceable. 3. Based on legal effect. 1. Executed contract. An executed contract is one where both parties have completely fulfilled their obligations under the agreement. Example. A sells a laptop to B, and B pays the full amount on the spot. Since both sides have performed their promises, it is an executed contract. 2. Executory contract. An executory contract is one where the performance by one or both parties is still pending. Example. A agrees to deliver furniture to B next week, and B will pay upon delivery. Since the obligations are yet to be carried out, this is an executory contract. 3. Partly executed, partly executory contract. In this case, one party has completed their part, while the other has not yet performed. Example: A has delivered the goods to B, but B has not made the payment yet. This is a partly executed and partly executory contract. Let's break down the key differences between Indian and English contract law in a super simple way. First, the source. In India, contracts are governed by the Indian Contract Act, 1872. In England, it's mostly based on common law principles and specific statutes. Next up, consideration. In Indian law, consideration is mandatory, even if it's just 1 rupee. Without it, the contract is void. But under English law, for deeds or specialty contracts, consideration isn't always required. Now, let's talk about the types of contracts. Indian law categorizes contracts as valid, void, voidable, illegal, and unenforceable. English law, on the other hand, classifies them into simple contracts, specialty contracts, and contracts of record. What about formality? In India, contracts can be oral or written. Both are generally valid if essential elements are present. But in English law, some contracts must be in writing or even under seal to be enforceable. And finally, the focus of each system. Indian law emphasizes free consent, legality of object, and capacity to contract. English law is a bit more technical, with greater focus on procedure and formal rules. So while both systems aim to uphold fairness and agreement, their structure and approach differ, and it's important to know both, especially if you're dealing with cross-border contracts. So now you know, not all contracts are the same. Classifying contracts helps courts decide rights, remedies, and validity. And remember, always look at consent, consideration, and legality before calling something a valid contract. Did you find this breakdown useful? Comment, neat, below and tag a friend who's struggling with contract law. And don't forget to like, subscribe, and follow us on Instagram and YouTube for more simplified legal learning.